Tonight, the Robert Durst saga, it continues. That is the millionaire real estate heir switched to a Louisiana prison with a mental health unit that as police search his Houston home. But there's still a whole lot of questions about the case, and our legal panel will sound off. Then, after racist chants were caught on tape, an entire chapter of an Oklahoma fraternity shut down. Where do we draw the line between, albeit ugly speech, but free speech and hate speech? And singer and actress Ashley Judd got trolled on Twitter. Nothing new there, but now she wants to sue the culprits. We ask you if she's got a case. Good evening and welcome to RFL. I'm Richard French. Thank you so much for joining us. And we're going to start with a case that everybody is talking about this week, the apparent televised confession of Robert Durst and the tape heard around the world.
What the hell did I do? Kill them all. Of course.
Now, that voice you heard was Durst in the HBO show Jinxed. He was caught on a hot mic. That's what we call in the business with the microphones on. The person doesn't realize, even if they've left the set, that the microphone is still recording. He took a bathroom break here, and he made comments that could actually put him in even hotter water. Now, for the sake of this conversation, and just for the sake of it, let's assume that that tape was not altered, as some suggest and others say was in fact what it was. But the question remains, is what he said on a hot microphone, not to the police, but in the recording of a show, and even in a restroom at that, admissible in a court of law? Here for analysis on this and other subjects this hour is our RFL legal panel. Jim Kasouris, a criminal defense attorney in Manhattan. He sits on the board of directors of the New York City Criminal Bar Association, frequently lecturing at New York Law School and the Bar Association in both Queens and New York City, and is a visiting professor at the University of Birmingham in England. To his left is Doug Van Nuys. Doug is a founding partner of Carson Van Nuys, focusing on, if I can say this in English, corporate misconduct, and selected by the Legal 500 as one of the most influential trial lawyers in the nation. And Mayo Bartlett. He is an attorney at the law offices of Mayo Bartlett PLLC and a former chief of the Bias Crimes Unit at the Westchester County District Attorney's Office. Gentlemen, all thank you for the time. And our first question, big question, is about that Durst confession, if we want to call it, and its admissibility. And I want to hear, as we do here, we have one debate. We're going to a whole host of stuff with the 60 minutes, but we have one debate, and we have opening arguments. And the first one is arguing that the tape should not be admissible, and that comes from Jim Kasouris. Go, Jim.
It's my position that tape is inadmissible. There's no question that an individual has a clear expectation, a right to privacy when he excuses himself and goes into a bathroom. That's initially. Now, some will claim that these statements are admissible because they were made to reporters, filmmakers, and not the state, and that the Constitution protects you only from state intrusion. Well, this may be so, but I would submit that under the circumstances we have here, HBO was actually an agent of the Los Angeles Police Department and the prosecution. Let's look at this. The timing of this arrest, based entirely on the investigation conducted not by law enforcement, who's been investigating him to no avail for decades, but by filmmakers who were clearly working with the police. It has been reported, for instance, that HBO agreed to turn over all the material they taped to authorities before airing it. Why? Obviously, in order to gain the advantage of the materials before Mr. Durst could realize that he may have incriminated himself and fled. I submit that this is not a simple case of a civilian tape recording another person. This was a powerful company doing the job of law enforcement for law enforcement under the guise of a documentary. At a minimum, the defense is entitled to all discovery related to the agreements between HBO and law enforcement, and an evidentiary hearing must be ordered to determine whether, in fact, someone in law enforcement went to HBO and said, hey, look, trip this guy up for us.
And he does it as the beat goes off.
Finally got that.
There we go. And now, to tell us why the Durst confession ought to be allowed in court, argues Doug Van Nuys.
Okay, Mr. Durst will probably argue that he had an expectation of privacy when he entered the bathroom. The whole theory of the Constitution is that you have an expectation of privacy under certain circumstances when you're dealing with the police. But here, he was dealing with filmmakers. Also, you can't have an expectation of privacy when you're wearing a microphone. The fact that you forgot to turn the microphone off is simply not a good reason to have a statement excluded. Mr. Durst was being recorded by a civilian. If a civilian is tape recording you, the statement is admissible in court if it's relevant to the crime committed. Mr. Durst will claim that his statement should be excluded because it's hearsay, but hearsay rules do not apply when the declarant is in the action which the party is either as an individual or a representative capacity. Mr. Durst will probably claim that his recorded statement should be excluded because it's meaningless. Whether what Mr. Durst said was meaningless is an issue that a jury is uniquely qualified to answer. The statement should be admitted into evidence.
All right. May, you've heard from the two of them. This is where you get to have the fun thing. You get to sit across and grill them like a judge does. Have at it.
Mr. Kasouris, are you suggesting that Mr. Durst had no idea that he was being recorded?
Well, we don't know that, and we need to find out. For example, everybody keeps saying you have no expectation of privacy when you have a microphone on and you should have turned it off. Maybe he thought that when he was not actually being interviewed for the documentary, that it would be turned off automatically, that he was able to actually go to the bathroom, undress himself, relieve himself without surrendering his right to privacy. So I don't know what was in his head, and I think that that's what's most important.
How is it that you assert that HBO is an agent of the police, though?
Well, yeah, I want to hear this one too.
Well, very simply, very simply. We know that they agreed to turn everything over before they aired it, number one. We know that for months and months and months they were in contact with the LAPD. We know that the LAPD for 2 decades has been trying to nail them and has been unsuccessful. And so you have HBO saying, we got them for 6 hours. I'm not saying 100% that's what happened, but I think we can all agree that an evidentiary hearing is required. I want to know what agreements were made between them, and the conversations that were had between them. And I think that it's very likely that there was at least some kind of an agreement between them for that.
But Jim, if they were acting as an agent, why did they sit on this tape for as long as they did? If they're really acting as basically in concert with the LAPD, why wouldn't they turn it over as soon as they caught it on the mic?
They did. Rich,
it took a while before they turned it over.
My understanding is that the LAPD has had this tape for months. So, you know, months and months. This is not something where HBO... Here's the answer. If HBO first aired it so that they could get the sensationalism of it and then turned it over, well, then they're thinking only of themselves and their ratings. They turned this over months before, and LAPD did nothing with it. Now, why? I don't know. But my understanding is they didn't sit on it. You may know better.
Well, Mr. Von Norris, what about your suggestion that because he had a microphone on, just a mere having a microphone on your person means you have no expectation of privacy? Suppose you had a cell phone with you. Do you have an expectation of privacy with your cell phone? Suppose that phone is recording your conversation.
Well, I think the difference is you expect a microphone to take your voice and send it out to the public. You don't expect a cell phone that's off to be recording you. There's a difference between the devices.
But do you agree that there's an expectation that when you go into the bathroom, you're not still being recorded?
Well, I think that there probably is an expectation that you have personally, whether there's a legal expectation of privacy. I don't think so. I think if you walk into a bathroom and you mutter to yourself and there's somebody in a stall in the bathroom and they hear you, they hear you.
Would it matter if that state is a one-party or two-party consent state?
Well, I guess the law of the individual state does matter. But
all right, so you've heard the pros and the cons here. When we come back, we're going to get into a whole lot of additional questions I have relating to the Durst case. Like, for example, something happens 10 years, 20 years, 30 years old. How hard is it to actually prosecute these cold cases? Everybody at the table has been now both a defense attorney and before that worked as a prosecutor as well. We'll get into that. Plus, we'll get the verdict here as the folks in the control room will serve as our jury here. We'll tell you who made the more convincing argument, whether or not that tape should be admissible or not. Stay with us. And we're back, and we're talking about whether the Durst tape is admissible in court here. And I got a bunch of other questions about the case. And you've heard the arguments from the two esteemed barristers to my left here. Now let's go to the verdict as we go to the control room. And what is the jury decision in there? I think we're getting suspense here.
Hung.
Not admissible.
0 for 2?
Oh, I tell you, Doug, I thought you had it this time. I think maybe Jimmy maybe got a hold of somebody in the jury pool in there.
Let's see you guys
wow. Mayor, I don't know about that one, right? All right. Okay, now let's talk about a couple other questions that I had relating to the case itself here. And talking about how some of these leads have to be getting cold. Take a look at this timeline. Kathleen Durst went missing in '82, and the other people were killed at least a decade ago that you'll see on your screen here. Now, I want to ask about the challenges that this creates for prosecutors. Mayo, how hard is it? I mean, we're talking about some of the dates here, you know, before DNA was such a staple in investigations. How hard does it become when you try and, you know, prosecute a case 30 plus years old?
Generally, the older the case is, the more difficult the case is to prosecute. Although, in a case like this, I think the biggest mistake Mr. Durst made was participating in this documentary in the first place, because what happens is you allow other potential witnesses to see what's been said, and it lets them realize that maybe they have that missing piece to the puzzle. So it would be, I think, extremely unlikely that you would prosecute just based on this television show itself. And even the letter itself, probably, although it gives you circumstantial evidence, you still would need some additional corroboration, and you want to go in with the strongest case you may have. But they may have developed new leads in the interim. There may be other witnesses who are able to provide those missing pieces.
Clients who just can't stay away from the camera. That's got to be some of the biggest nightmares as an attorney, right?
There's no question, and we were talking about it before, you know, the character in Dostoevsky's Crime and Punishment. People are inclined, they want to talk, whether it's to try to exonerate themselves and get themselves out of a mess they're not even in yet. They create it. And that's, I mean, he just thought he had it on him.
Do you sometimes feel like you got to almost beat the clock when you get a client in there in custody? You got to get there as quick as they can because they can't stop themselves from opening their mouths.
We'll all tell you. We make phone calls to the precinct immediately to advise the officer, and then you hope you have an honest officer who will acknowledge your phone call that the man is represented. Don't talk to him. Absolutely.
You almost have to make a notation,
Absolutely.
even that I spoke with this detective at this time, and that, you know,
call from a
attorney-client
phone that you can show it's the number. Yeah.
You know, Rich, in a case like this, it's interesting because there's this HBO documentary that's out that everybody's seen, and if they haven't seen it, they're going to see it now. If anybody else comes forward after this and claims to have relevant information, you know, statements, things like that, the perfect cross-examination is going to be, you heard it on HBO.
Yeah.
Right?
Yeah. Interesting.
After 30 years.
You know, Doug, there's a debate about the timeline a little bit. What HBO apparently, a couple of years ago, did the interview that people have seen in Jinx. By the way, really compelling show if they haven't seen it. They claim when they're going through the raw tape, they only discovered this admission, if we're going to call it that, about 9 months ago, and then they turned it over to the cops. Is there a standard rule as to how much a media company, what responsibility they have, first and foremost, to law enforcement, rather than just having, let's say they didn't turn it over to the cops, and let's say, wow, we got some compelling video, we're going to air this as an exclusive right on the air. Does law enforcement, could they argue, hey, you find anything that's relevant to the commission of a crime, you have to, by law, turn it over to us first and foremost?
Well, you're talking about mandatory reporting, special relationships, things like that. I don't see how a media company has any mandatory reporting rule or a special relationship with law enforcement. I don't think they have to turn over anything they don't want to turn over.
But that goes to my argument that we made during the debate. I mean, there was a relationship here. There was a relationship here from the inception of this documentary, from the research, from the conducting of it, agreements to turn stuff over. They were working together. Whether it rises to the level of agency is a different story, but they almost created the obligation.
Except there's a contractual relationship between HBO and Mr. Durst. The other thing is that there's nothing that would compel them to hand over that information to the police, but there's nothing that prevents them from doing so unless it's contractually stated.
Now, one thing people also may have caught from this documentary was it also has to do with physical evidence, specifically handwriting. Now, the comparison of an anonymous letter sent to Beverly Hills Police to Durst's handwriting was a major turning point, at least if you go by the documentary, and it led to Durst's apparent confession when he saw those letters. Now, Mayo, can handwriting analysis be used to prosecute him? And also, you know, with the advance of technology right now, with what people can print out and stuff like that, you've been on both sides of this. How much can people put two letters and say, oh, same guy?
It's going to be a battle of the experts, and basically handwriting analysis is a powerful tool, but it's not perfect. And we're learning now that even fingerprints are not perfect, and the certainty is much less than we had been led to believe in previous decades. So the reality is that there's a good chance that Mr. Durst is going to have the best experts, and those experts are going to be able to say, well, lots of people write in block print like that, and it's not necessarily Mr. Durst. They're probably even going to be able to go out there and tell you what percentage of people misspell Beverly. And it's going to be a surprisingly larger number of people than you would think.
In terms of standards, people do voice comparisons, right? Is it enough that if you're looking at the jury and they're not along with you, is that really the only threshold that matters here? Or from an admissibility standpoint as to whether or not this is compelling, is there, black letter law here that says yes or no, that is or isn't acceptable? I guess the same thing was decided as it relates to polygraph tests, right?
You know something? Here's the problem. With handwriting analyses, the jury instruction is you've heard from the experts and you can consider them, but ladies and gentlemen of the jury, you have to look at these things and make your own determination, and that could be his biggest problem, because you look at those two writings as a layperson, and
first of all, it's crazy writing with the block lettering and the whole thing.
But there are similarities in the L's, the way the top of the B, you look at it as a layperson, and judge tells you, irrespective of what the expert tells you, look at it, and that could be a problem with these writings.
Well, you have to wonder, though, if you know you've committed this crime, why would you write it in your actual handwriting? Why wouldn't you go to lowercase? The other thing is that I always have an issue. Well, that's a good point.
Series,
But you always have to wonder also, when you ask a jury to listen to two experts, and that jury doesn't have any expertise in that area themselves, it becomes a popularity contest, essentially, and then you start to also give more weight based upon whether you saw the documentary or other extrinsic evidence. And the letters themselves ultimately, are not given weight based upon their individual merit.
I've always thought, though, Doug, there's always one person on that jury that loves to believe in conspiracy things. And the more that you enter this in as part of the evidence, whether it's handwriting, or it's like the gloves with OJ, right? That somebody's looking for something, just to be, a pain in the you-know-what. Does this almost confuse things, because that's now the standard, that if they believe the letter could have been altered, or if they believe the tape was doctored, or if they believe whatever, that in many ways this helps the defense because people can be focusing on that instead of maybe some of the empirical evidence? Jury
selection. You're talking about jury selection. You got to get the right jury. But what Jim was saying is true. At the end of the day, I've actually had a case as a prosecutor with handwriting. And what I was arguing the whole time, what the defense attorney was arguing the whole time, at the end of the day, the jurors were looking at completely different letters that they were focusing on. So it's a great piece of evidence, because at the end of the day, it's your common sense. You can actually look at the handwriting and make your own decision.
You still do have the issue of chain of custody. You have to be able to establish, for these letters even to be admissible, that it wasn't altered. And that's where your timeline is very important, because where were these things over the past, how many years has it been? So that's one thing. And even with respect to the tape itself,
did anybody doctor it?
Was that doctored? Is that exactly what was said? Is it in context? Is anything missing there? Has the file been altered? All of that's going to come up.
Oh, I would love. I like the tape.
Yeah. All right. When we come back, we're going to get away from the Durst case, and we're going to get to another clip that I'm sure many of you have already seen. And we go to the University of Oklahoma, as well as a couple other college campuses. But the University of Oklahoma president now investigating those racist chants that a fraternity made during a bus trip. Every member of that fraternity has already been punished. The frat house shut down, and just about everybody agrees what they said wasn't just wrong, but was just completely offensive. But we're going to ask our legal panel whether it is, even though ugly, legally protected by the First Amendment.